Hello, hello. Good evening, everybody. Hello, good evening. Hello, hello. Good evening. Welcome to the session. We'll be doing a mock session today where I have brought some questions that are a bit important, that are important for your exams. Okay? So we'll just read the question, give the answer, and move to the next question. We'll not go in the explanation, we'll just read the question and attempt the answer. Okay, I would request you all to write your answers in the chat section so that you know कि आप लोग कहाँ तक, how much of the content do you know, and how much prepared you are for the exams. And it is good to give answers so that you can know कि what is the position at which you are right now. ठीक है, आपको जहाँ पे what happens ना, when you give wrong answer, you in the exam you remember कि मेरे को ना यहाँ पे मैंने गलत किया था. So try to give answers even if you are wrong, doesn't matter, just try and give the answers. ठीक है, let's start. So we are doing BRBL. I'm Advocate Devshri Dua. First question for the day is, which authority is responsible for approving the appointment of independent director in a public company? Answer please. Which authority is responsible for approving the appointment of independent director in a public company? Registrar of the company, central government, shareholders, or board of director? It is shareholders. The answer is C, shareholders. Next, what is the minimum number of independent directors required in a public company? Minimum number of independent directors. It is 1/3 of the total directors. A. Next, which of the following is not a regulatory body in the Indian banking sector? RBI, SEBI, IRDAI, Ministry of Finance. Question number 3. Anji, waiting for your answers. It is Ministry of Finance. Next question. What is the maximum tenure for a managing director in a bank without RBI approval? Without RBI approval, for how much long time can a person stay in a bank as a director? It is 5 years. Next question. What is the maximum penalty for non-compliance with the Prevention of Money Laundering Act? Maximum penalty. Maximum penalty for non-compliance. There is no limit. The answer is D. Next question. Which type of charge does not require registration with the registrar of the companies? There is one charge in the following options which does not require registration. The answer is pledge. Pledge and lien do not require registration. Next, Under the FEMA Act, transactions involving foreign currency fall under which category? Foreign currency transactions. See, current account transactions means the transactions which do not alter our liabilities and assets. Capital account transaction means those transactions which affect our liabilities and assets. Okay? So, what will be the answer for this question? Yes, very good. It is C, both. Next, which document is mandatory for incorporation of a company? Which document is mandatory for incorporation of a company? Yes, very good, Dinanaji. C. It is both the documents, a memorandum of association and article of association. Next, central government can authorize a banking company to conduct its business outside India under which section of BR Act? Which section allows a banking company to conduct a business outside India? Section 23, 22, 26, 29. It is section 22. Okay. B is the answer. Next question. Which of the following is true regarding the limitation of voting power of shareholders of a banking company? Good question. A shareholder can have a voting power up to 10%, 15%, 5%, or no voting power. Which of the following is true? What is the limitation? Yes, very good, Rajendra ji. It is A, 10%. Next, which of the following statement correctly describe the regulatory functions of RBI? RBI has power to grant or cancel banking license under BR Act. RBI supervises and regulates only banking public sector banks, not NBFCs. RBI can appoint and remove directors and top management of bank under certain conditions. What statements are correct? Yes, absolutely correct. A is the answer. Statement number 1 and 3 are correct. Very nice. Which of the following statement reflect the dual regulatory structure applicable to cooperative banks? State cooperative banks are exclusively regulated by the Registrar of the Cooperative Societies. RBI has power to supersede the Board of Director of a cooperative bank under Section 36 AAA. Cooperative banks operating in multiple states fall under the Multiple State Cooperative Society Act 2002. Yes, very good. B is the correct answer. Statement number 2 and 3 are correct. Next, which of the following statement accurately reflect key provisions related to licensing of banking company under BR Act? A banking company must obtain a license from Ministry of Finance before it can commence or carry a banking business in India. RBI can inspect the book of banking company before granting a license to ensure it has an adequate capital structure and earning prospect. Courts can overrule RBI's decision to refuse banking license even if it is based on relevant material. Anji, waiting for your answers. Please write your answers in the chat section. Only statement number 2 is correct. Court do not interfere in RBI's decision. कोर्ट कभी भी आरबीआई के डिसीजंस में इंटरफेयर नहीं करेगा. दिस वाज हेल्ड इन द केस ऑफ शिवा भाई वर्सेस आरबीआई. ठीक है. And you do not need a license from Ministry of Finance To run a banking company, to run a bank, you need a license under Section 22 of BR Act from RBI. Money matter में RBI का ही रोल आता है सिर्फ. Next, a group of investors is exploring setting up a new universal bank in a private sector in India. The proposal was initiated after the release of 2016 guideline on the tap licensing. Consider the following factors pertaining to their application and assess their permissibility and relevance under RBI norms. Which of the following factors are aligned with RBI's 2016 guidelines? The promoter group includes an industrial house that proposes to hold more than 40% equity in the bank through a non operative financial holding company. A proposed universal bank has foreign direct investment exceeding 74% through automatic route. A promoter bank group submit a detailed business plan including capital structure and product offering along with risk management system. Who will tell me what is on the tap licensing and what is the correct answer for this question? On the tap licensing. So I've received A as an answer. But who is going to explain me what is on the tap licensing? A is the correct answer. E. Next. FDI beyond 74% is not allowed. Next, a microfinance institution and a group of professionals are evaluating conversion to an establishment of small finance bank. Consider the following scenario to assess whether they met the RBI guidelines on tap licensing of SFBs. Which of the following statements are correct as per RBI guidelines? The MFI proposes to incorporate the SFB as a public limited company under the Companies Act 2013. The professionals have a combined 3 years experience in banking and propose a capital of 100 CR. The MFI intend to continue its micro loan book, existing micro loan book, and expand into basic saving and payment services. Again, a good question. The question is on the screen. The correct answer is A. Statement number 1 and 3 are correct. Next. Which of the following statement related to opening or changing a banking company's place of business under Section 23 of BR Act are true? A temporary branch can be opened during festive season prior RBI approval if it operates for under 1 month. Banks incorporated outside India are exempted from RBI's permission from shifting existing branches within same city. RBI may impose general or case specific condition while granting permission to open a branch. Again, a very good question. You will find such question in your exams. Again, keep replying to the answers in the chat section. The answer is A. Statement number 1 and 3 are correct. Next, XYZ Banking Company, an Indian banking company, is proposing to expand its operation. It currently operates only in one state, where its principal place of business is in Nagpur, and has four other branches, two in the same district and two in different districts of same state. The bank was established in 2010. Recently, the bank has proposed to expand into Mumbai and Kolkata. Nagpur is a non-metropolitan city, whereas Mumbai and Kolkata are metropolitan city, and it is reviewing its compliance under Section 11 of the BR Act. Which of the following statement are correct? The bank is presently subject to the clause for banks with all place of business in one state excluding Mumbai and Kolkata. The minimum capital required and reserves for this present structure before expansion cannot exceed rupees 5 lakh rupees. Upon expanding to Mumbai and Kolkata, the bank would require a minimum capital and reserves of rupees 10 lakhs. As we are expanding from a non-metropolitan area to a metropolitan area, we are expanding, the capital requirements do change. What will be the correct answer for this question? All the statements are correct. D is the correct answer. Next. Alpha Bank Limited, a foreign bank incorporated in Singapore, operates three branches in India, one in Mumbai, one in Kolkata, and one in Bangalore. The bank entered a net profit of rupees 10 crore from its Indian branches for financial year 24-25. The bank seeks clarity on its obligations regarding capital deposits with RBI, profit based deposit, and consequences if it is decides to exit the Indian market. Which of the following statements are true as per section 11 of the BR Act? The Alpha Bank must deposit rupees 20 lakhs with RBI in cash or unencumbered approved securities. The bank must additionally deposit rupees 2 crores with RBI, that is 20% of India profit. The deposit with RBI can be made entirely in cash or entirely in securities or a mix of both. The question is on the screen, waiting for your answers. All the statements are correct. D is the correct answer. Next, again, same paragraph, different statements. In the event of cessation of business in India, the deposit forms part of bank's global asset and is governed by Singapore law. The RBI can permit expansion from deposit requirements for a limited time if alpha's deposit are considered adequate. Yes, B is the correct answer. Very good. Next, which of the following statements correctly relate to shareholding restrictions and RBI approval in banking companies? A person can hold an percentage of shares in a banking company but cannot vote more than 10% of total voting unless allowed by RBI. The RBI can gradually raise the voting rights ceiling from 10% to 49% under Section 12, subsection 2 of the BR Act. As per Section 12B of the BR Act, RBI approval is required before acquiring 5% of the more shares in banking company, including indirect holding. See, this voting ceiling cannot be increased. Okay, making statement number 2 as incorrect. A is the correct answer. Next, the maximum ceiling is 26%, not 49%. Learn करेंगे इस point को. Next, which of the following statement correctly relates to shareholding restrictions and RBI approval in banking company? RBI approval is not required if shares are acquired through inheritance and not by agreement or transaction. The Companies Act governs transfer of banking company share only if the holding remains under 5% of the paid up capital. See, RBI follows fit and proper criteria. It doesn't matter कि आपने how do you inherited, you got the share via inheritance or by purchasing them. RBI, the intention of RBI is fit and proper, making statement number 1 incorrect and statement number 2 is incorrect as well. D is the correct answer. Next, state which of the following statement are true. A public sector bank is a corporate body corporate created under a special statute. A banking company is registered under the BR Act. Cooperative banks are registered in under Multi-State Cooperative Society Act or State Cooperative Society Act. Which statement are correct? Which of the following statements are correct? The answer is B, 1 and 3. Next question. Which of the following statement correctly describes RBI's regulation on deposit interest rate? RRBs can offer differential rates for deposit starting from rupees 1 crore and above. RBI's direction under Section 35A must align with public interest or banking policy. Question is on the screen, waiting for your answers. Both the statements are correct, absolutely correct. C is the correct answer. Next, which of the following is are false? We have to tell what of which statement is false. Central government can give directions to RBI. All kinds of businesses of banks are regulated only by our Reserve Bank. Central government is the primary regulator of the bank. State government have no control over cooperative banks. We have to tell क्या false है. What all statements are false? The central government can give directions to RBI, and the rest of the statements are false. That makes D as the correct answer. Next statement. Banking companies are not permitted to give dividend until all the dash are written off. क्या write off करना पड़ेगा before giving the dividend? What all things are needed to get written off before giving dividend? Bad debts, expenses, capital expenses, amortization of dividend. It is capital expenses. C is the correct answer. Next. A director of a banking company should not have dash in any other company. क्या नहीं होना चाहिए? This is an important question. A very good question. We have to check this specific interest. अगर ये interest नहीं है, only and only then the director, that company will be allowed to have some relation, some borrowing agreements with the banking company. The answer is C, that is substantial interest. Next, which of the following statement are false? We have to again tell क्या false है. The maximum period of office that may be held continuously by an ordinary director in a banking company is 8 years. The decision of the board of directors during the period when the board's constitution is defective shall be void. The post of chairman of a banking company may be on a part-time basis. The chairman of a banking company can hold office only for a maximum period of 8 years. What statements are false? So when we are talking about the ordinary director, it is 8 years. But when we are talking about chairman, it is not 8 years. Statement number 2 and 4 are false. D is the correct answer. Which of the following statements correctly reflect the interaction between RBI's directives and court intervention regarding interest rates? The Usurious Loan Act 1918 is still applicable to bank loans for rate scrutiny in special cases. Is the Act of 1918 still applicable in India? The Section 21A of the BR Act overrides state level debt relief laws and Usurious Loan Act. So in the first statement it is saying कि Usurious Loan Act लगता है, but in second statement it is saying section number 21A override करता है. Next is Courts cannot interfere in banks' interest rate if RBI directives prescribe both minimum and maximum limit. Courts generally do not interfere in any of the RBI's banks matter. Okay? Making B as the correct answer. Statement number 2 and 3 are correct. Next, the minimum period for preservation of records under PMLA 2002 for certain suspicious transaction after its reporting etc. is कितने सालों तक हमें रिकॉर्ड्स को कम से कम संभाल के रखना पड़ेगा सस्पिशियस ट्रांजैक्शन के बाद? What is the minimum period required? What is the minimum period? Waiting for your answers. Please give me the answer in the chat section. Yes, absolutely correct. It is 10 years. D is the correct answer. The area of operation for a LAB is usually restricted to a maximum of dash geographical contiguous district. 4, 2, 6, none of these. The answer is D. The answer is 3 years basically. 3 geographical districts, not 3 years. So none of these I guys can answer. Since you have to learn this point, I have written it down. ठीक है, learn करेगा मैं से. Next, the chairman and MD of SBI are appointed for a period not exceeding 4 years and are eligible for reappointment. True or false? True or false? ठीक है. Answer please. Answer. Waiting for a reply. ठीक है. 4 years नहीं है. It is 5 years. The statement is false. Not exceeding 5 years and are eligible for reappointment. Again, a pointer to learn. Next, Dash in is a bank by which a regional rural bank is sponsored, and it holds 35% of the issued capital of RRB, while Dash holds 50% and the Dash holds the remaining 15% of issued capital. A very good question. I need an answer for this. I've explained this question again and again. Rajendra ji is saying C. Yes, very good, Rajendra ji. It is C. C is the correct answer. Sponsor bank holds 35%. Central government owns 50%, and the state government owes the rest 15%. That is C. Okay. Next, after liberalization and globalization initiated in 1991, reforms have been introduced in Dash, monetary policy, banking sector, forex market, capital market. Post 1991, that is जब हमारा liberalization, globalization, privatization scheme आई थी, कौन से sectors में, in what all sectors there were reforms? The banking sector got reformed. The forex market got reformed, the capital market got reformed, or the monetary policy got reformed? What will be the correct answer? The answer is C. That is, the banking, the monetary, the banking and the forex got reformed. Next, which one of the following is not the holder of a check? A check made out to the order of X and couriered but not received. Made out, the check has been made out in the favor of X. Courier हो गया है, receive नहीं हुआ है. The bearer check found lying on the road by Y. A duplicate check issued to Z who had misplaced it. None of the above. Not बताना है, not holder in, not the holder of a check. Who will not be a holder of check? Who is the holder of check? जिसके नाम पे check issue है, ठीक है? X के name पे the check has been issued. Z के name पे the check has been issued. Is the check issued in the name of Mr. Y? No, it is not. So Y is not the holder of check. B is the correct answer. Which of which is not the criteria to be fulfilled for a person to be a holder in due course of a check? The check should be crossed. It should have been acquired for consideration. It should have been acquired before its maturity. All of the above. C. Who is a person holder who will be called as a person holder in due course? Who will be called holder in due course? A person who gives, suppose I have received a check and a check has been issued in my favor. I want the money urgently, but the check is post dated. So I can give the check to Mr. somebody else and get the money for it. That person will give me a consideration and he'll take the check and say ki I'll get it in cash when the date comes, and this is the process. That person will be called as holder in due course. Okay, so the answer here will be that this person has acquired the check before maturity. Post dated check था, maturity से पहले ले लिया, and for consideration he has paid consideration, but there is no such requirement of the check being crossed. So A is not the correct answer. It is not a criteria. Which of the following circumstances indicate a material alteration? When the operation of sorry, when the operation of instrument and liabilities of parties are altered, when the business effect is altered. Material alteration क्या नहीं है? What is material alteration? ठीक है? When the business effect is altered when used for business purpose, when a change impacts an instrument in such a way that it starts speaking a different language in legal terms from that which it originally spoke, sorry, or which changes the legal identity of character of the instrument, or D, all of the above. See, after reading this, you'll find ki all, if we make changes, all such changes, they'll be considered as material alteration, and D is going to be the correct answer. Next, a current account transaction alter the asset or liability outside India of a person resident of India. Current account में क्या liabilities and assets change होते हैं? I have taught this point. Current and capital का difference हम पढ़ चुके हैं. Current में आता है where the asset and liabilities do not get altered, and capital में आता है where the asset and liabilities get altered. So the question here is current में the assets and liabilities get altered. So the statement is false. Current account transaction means a transaction other than capital account transaction. For example, payment due with respect of foreign trade done, other business, services and short-term banking and credit facilities in ordinary course of business, payment due as interest on loan and income for investment, remittances for living expenses of parents, spouses and children residing abroad, expenses in connection with foreign travel, education, medical care of parents, spouse and children. You have to learn this लर्न 5 स्टार क्वेश्चन है, इसको आपको लर्न करना पड़ेगा कि कैपिटल और करंट में क्या आता है. सो ये जो एग्जांपल्स है ये करंट अकाउंट ट्रांजैक्शंस के हैं, एंड कैपिटल अकाउंट ट्रांजैक्शन में द असेट्स एंड लायबिलिटीज गेट ऑल्टर्ड. Next, a financial instrument whose value is derived from change in interest rate, foreign exchange rate, credit rate or credit index, price of security, etc., also called underlying, or any other underlying, or a combination of more than one of the foresaid, are called dash repos, reverse repos, derivatives, none of the above. हाँ जी, waiting for a reply. They are called derivatives. ठीक है, financial statements whose value is derived from change in interest rate. जो financial instrument है जिनकी value आती है by the change of interest rate, foreign exchange rates, credit rating or credit index, price of security, etc., they are called underlying, also called as underlying. ठीक है, or any other underlying or a combination of more than one or aforesaid, इनको हम कहते हैं derivatives. 5 star question. Next, for RBI to consider authorizing a company or corporation to operate or regulate the existing clearing house or new clearing houses of banks, in order to have a common retail clearing house system for the bank throughout the country, what percentage of equity of shares should be held by public sector banks? What percentage? Less than 51, less than 60, less than 80, less than 10? What will be the correct answer here? So you'll find such questions in the exams. Not less than, sorry, not less than. देखो, not less than में कितना होगा? Not less than, what will be the answer? You waiting for your reply? It is not less than 51%. A is the correct answer. Prior approval is required front RBI before a system provider causes any change to take place in the system which would affect the structure or the operation of the payment system. However, how many days notice should be given to the system participants after the approval by the RBI? So we have to give a notice to the system participant. Okay, and what is the what is the number of days required for this notice? How many days notice do we need to send? Yes, exactly. Very good, Rajendra ji. 30 days. Next, hypothecation is an implied pledge in cases where. What is hypothecation and what is pledge? Well, tell me the difference between hypothecation and pledge. Constructive possession of goods is given, delivery of good is given, constructive possession of obligation is given, none of the above. Hypothecation में possession of goods is not transferred, whereas in pledge possession of goods is transferred. ठीक है, अभी पूछ रहे हैं हाइपोथेकेशन इम्प्लाइड प्लेज कब बन जाता है? इम्प्लाइड प्लेज किस सिचुएशन में इम्प्लाइड प्लेज बन जाएगा? It is when we give constructive possession, है ना? When we are giving possession, there is some sort of possession given. Hypothecation will be changed to pledge, क्योंकि हमारा possession ही तो pointer है जो यहाँ पे different है. Possession यहाँ hypothecation में नहीं दिया है, pledge में दिया है. तो as soon as we give the constructive possession, constructive मतलब not the actual possession but some sort of possession that will make the other party, the pawner, that he is the pawnee, that he has the possession of the goods anyhow. That makes A as the correct answer. Charge is not requiring registration. Charge not requiring registration. Charge is not requiring registration. दो बार की रिपीट है. Okay. What charges do not require registration? Corporate guarantee arising due to operation of some specific law with where registration is not required. Hundi, which is a negotiable instrument, all of the above. It is charge arising. Okay, that will make sense more. What is the correct answer? All of these charges do not require registration. If it is a corporate guarantee, if it is arising out of some law operation, and if it is a hundi, and that is a negotiable instrument, such charges do not require registration. D is going to be the correct answer. Next, A finds B's watch and gives it to him. B promises to give A a sum of rupees 100 in this. Is this a contract? Will this form a contract? देखो, Mr. A, such questions will come and you will get confused, क्योंकि यहाँ पे ना कोई ऑफर हुआ है, ना कोई प्रॉमिस हुआ है, ना एक्सेप्टेंस हुआ है. ठीक है, it is saying this, there is a promise. For a contract to get converted into a contract, there is a process. ठीक है, offer plus acceptance is equals to promise. Promise plus consideration is equals to agreement. Agreement this is one of the basic question of law, and people generally give wrong answer for this question. Agreement which is lawfully enforceable makes a contract. ठीक है, here B को ना रास्ते में चलते हुए उसकी घड़ी मिल गई A की. ठीक है, A finds B's watch. A found B's watch. A को यहाँ रास्ते में B की वॉच मिली एंड उसने वो B को जाके दे दी. B got happy and said, I'll give you 100 rupees. मैं तुम्हें 100 rupees दूंगा. Now can A ask B कि पैसे दो. Now can Mr. A ask B, give me the money. Was there an acceptance and offer here? See, यहाँ पे acceptance and offer की कोई need नहीं थी. He genuinely promised. इसने कहा कि I'll pay you some amount due to some happiness. ये एक sort of contract बन जाएगा because यहाँ पे B ने अपने आप को खुद oblige किया है towards A. B has made himself obliged to A, and here A can enforce this contract. So the answer is yes. The agreement must be entered for a lawful object. Example, it should not be forbidden by law. उसने A को दिया पैसे due to his happiness. He can, ठीक है, and or must not be fraudulent. That is, to commit a fraud must not be immoral, must not be opposed to public policy. And here A will ask B to make the payment. If B doesn't, A can sue B. Okay, such questions will be get, you will get such questions in the exams and you will think कि ये तो कॉन्ट्रैक्ट नहीं होगा, यहाँ तो प्रपोजल और प्रॉमिस हुआ नहीं, एक्सेप्टेंस नहीं हुआ. ठीक है. Insurance policies are contracts which are in nature of. Insurance क्या होता है? When I was teaching you, this specific example was given by me. ठीक है. इंश्योरेंस किस तरीके का कॉन्ट्रैक्ट होता है? Is it guarantee? Is it pledge, bailment, indemnity? So in guarantee, there is a guarantor who says ki if the debtor doesn't pay, I'll make the payment. In pledge, we give the goods and take money on loan, the movable goods. In bailment, we give the goods for some work. जैसे वो work पूरा हो जाएगा, we'll get the goods back. ठीक है. In indemnity, indemnity का मतलब क्या होता है? If you face some losses, will make good for it. इंश्योरेंस पॉलिसी में क्या होता है कि इंश्योरेंस में अगर आपको किसी तरह का नुकसान होता है, सपोज यू हैव टेकन कार इंश्योरेंस और हेल्थ इंश्योरेंस और एनी सॉर्ट ऑफ इंश्योरेंस बेसिकली, एंड यू हैव गॉन टू the hospital, if it is this insurance, health insurance, or if your car get damaged, if you get any sort of loss, basically the insurance company will fulfill that. Okay, so it is a contract of indemnity. D is going to be the answer. Next, there are parties in a contract of indemnity. There are dash parties. कितनी parties होती है indemnity में? इंश्योरेंस में कितने लोग होते हैं generally? How many people are there in insurance? Two. A is the correct answer. Principal. Okay. Principal debtor need not pay the surety after the surety has paid the amount to the creditor. Principal debtor surety को नहीं पेमेंट करेगा. Let's not see the answer ऐसे. आप एक बार नॉर्मली आंसर दो. प्रिंसिपल डेटर को पेमेंट करने की नीड नहीं है श्योरिटी को, बिकॉज श्योरिटी ने पेमेंट कर दिया. माय क्वेश्चन गॉट. आंसर प्लीज. दिस इज, देखो, आई एम अ डेटर, ये ए है, ये है क्रेडिटर, ये बी है डेटर, ये सी है गारंटर. प्रिंसिपल डेटर नी नॉट पे विद श्योरिटी. श्योरिटी को हम गारंटर भी कहते हैं, श्योरिटी बोल देते हैं मैं यहाँ पे फॉर दिस केस. ठीक है. द श्योरिटी हैज पेड टू द क्रेडिटर. यहाँ पे एक कॉन्ट्रैक्ट है, इनके बीच में कॉन्ट्रैक्ट है और इनके बीच में कॉन्ट्रैक्ट है. इनके बीच में क्या कॉन्ट्रैक्ट है? टू गिव लोन. इनके बीच में लोन है. इन दोनों के बीच में है कि इफ बी डजंट पे, आई विल मेक द पेमेंट टू यू, एंड इफ सी pays on behalf of Mr. B, Mr. B will be obliged to pay to Mr. C. ठीक है. B will be, जैसे ही C ने A को पेमेंट कर दी, the moment C makes the payment to Mr. A, Mr. A will go from the picture, and now Mr. C will be the creditor. He will step into the shoes of the creditor, and Mr. B will still be liable to make the payment. ठीक है. So this statement above is false. Let's see this question. Surety is also known as dash. Surety को हम क्या कहते हैं? Just I have just told this to you. What is a surety also known as a guarantor, right? As a guarantor. C. Liability of a surety is dash that of a principal debtor. Coextensive primary to secondary to. What sort of liability does a surety have? Coextensive, primary or secondary? It is coextensive. जितनी liability surety की है उतनी ही liability guarantor की है. If the surety has taken a loan of 5 lakh rupees, the guarantor is supposed to make the payment of 5 lakh rupees. ठीक है? Not more than that, not less than that. Plus, if surety makes the payment, guarantor does not have to. If guarantor makes the payment on behalf of surety, the I'm sorry, I've used the wrong word. See, surety, if the debtor has made the payment, surety doesn't have to make the payment. If the debtor does make the payment, surety doesn't have to make the payment. If the debtor does not make the payment, the guarantor has to make the payment, right? It is coextensive. जितनी जितनी liability debtor की है, same liability surety की है. Making A as the correct answer. Next. A gives a guarantee to C for goods to be supplied by C to B. A gives guarantee to C for goods to be supplied by C to B. So Mr. C here is the creditor. Goods are given to whom? The goods are given to Mr. B. Mr. B is the debtor. And Mr. A is the surety oblique the guarantor. Okay. C supplies goods to B and afterwards B contracts with his creditor to sell them certain properties of his in consideration for all the creditors, releasing B from all their demands. Here B is now, after the settlement, not a debtor of C. A is therefore dash for this surety ship to C. A good question. A very good question. B. C. If you'll give me a reply for this, very good. I'll explain this question otherwise. Okay. A very good question. क्या आपको ये क्वेश्चन समझ आया? Did you understand this question at all? C supplies goods to B and afterward B contracts with his creditor C. सारे creditors, उसके जितने भी creditor है including C, to sell them certain properties of his. अपनी property उसने C को दे दी. In consideration for all the creditors. ठीक है? अपनी प्रॉपर्टी दे दी, अपना लोन खत्म कर दिया. Releasing B from all their demands. The moment B is released from the payment to C, B is free of any sort of liabilities. Okay? As the moment B makes payment to C in any form, either in the form of cash or in the form of property or any form, basically, as soon as B is discharged, what will be the position of A? What will be the position of A? जब C B की ही कोई liability नहीं है, क्या A की liability रहेगी? Yes, very good. A will also be discharged. If a complaint made by customer to a RE, that is regulated entity, is not replied, what is the minimum period after its receipt by the RE? May the customer make a complaint to the ombudsman? In how much time? कितना time period है एक के पास, सॉरी, कस्टमर के पास to go to ombudsman? How much time does a person, a consumer has to go to the ombudsman? The answer is 1 month. A. Which of the following statute provides the current definition of MSMEs in India? MSME की definitions, current definition MSME की कौन देता है? The MSME Act, the Delayed Payments Act, Minimum Wages Act, Factories Act. Logically, if we have a specific act for it, definitions will be in it. A is the correct answer. Very good. Next. What are the revised norms regarding investment in plant and machineries in respect of micro enterprises engaged in manufacturing as per MSMED 2006? Investment in plant and machinery not exceeding rupees 25 lakh. Investment in plant and machinery not exceeding 1 CR. Investment in plant and machinery not exceeding 2 CR. None of the above. Yes. It is none of the above. What will be the correct answer? कितने इन्वेस्टमेंट्स हैं अब 2025 के अमेंडमेंट के बाद राजेंद्र जी? For micro, it is 2.5 CR and turnover investment. Turnover 10 CR. Small 25 CR. Turnover 100 CR. Medium 125 CR and 500 CR. Yes. Yes, very, very good. Very, very good. It is 2.5 CR. Very good. Very good. Okay? So it is none of the above. Next. Where an application is made to a court by a buyer for setting aside any decree or award made either by facilitation council or by any institution or center providing alternate dispute resolution services, what percent of the amount of the decree award is to be deposited with the court by the buyer? Waiting for your reply. Yes, abs. Yes, 75 to 25, 50 applies here too. It is 50%. Next. Can you see the screen? Yes. Yes, Rajendra ji, 75%, 50%. We do not want a deterrent effect to be on any sort of person. Just because that person wants to go and appeal doesn't make him a wrongdoer. Okay? where movable properties in possession of bank can be sold by bank without the intervention of court. Now a court order is required to sell a security. Yes. Now this should be no. Let me get this. अब ठीक है. No, a court decree is required to sell the security. Yes, bank can sell as provided in the Contract Act. Yes, as SARFAESI Act has made provisions for the fact. No, until the account is not declared NPA by the bank. Where you see. सेलिंग की बात आ रही है यहाँ पे राजेंद्र जी. ठीक है. द पॉइंट इज सेलिंग. पोजेशन लेने की बात नहीं है, सेलिंग की बात आ रही है. सो फॉर पोजेशन पहले हमें एनपी डिक्लेयर करना पड़ेगा, बट नॉट फॉर सेलिंग. सेलिंग से पहले, पोजेशन से पहले हम एनपी डिक्लेयर कर चुके हैं, है ना. सो यस, such provisions are made in SARFAESI. C is the right answer. Okay. Next, any directions issued by RBI under SARFAESI Act has dash effect and is dash on the parties concerned. क्या effect होता है इसका? Then let me give you an option. What will be the correct answer here? What will be? देखो, आरबीआई की गाइडलाइंस हमेशा स्टैट्यूटरी होती है, बिकॉज आरबीआई गेट्स पावर फ्रॉम वेयर, फ्रॉम द आरबीआई एक्ट. ठीक है. एंड दोज guidelines, those directions are binding, making A as the correct answer. Statutory होती है and binding होती है. Beside the SARFAESI Act, some other laws require some registration of charge created in the property. Is such double registration avoidable? SARFAESI के अलावा बहुत सी जगहों पे हमारे को रजिस्ट्रेशन की नीड होती है, राइट. सो क्या ये डबल रजिस्ट्रेशन को अवॉइड कर सकते हैं? Yes, the creator can choose under which law he needs registration. No, registration under SARFAESI Act as well as any other applicable law will have to be made, as the SARFAESI Act is not substitution of other laws. Yes, if one charge noting is by a registered document. D, no, as the civil courts and DRT still have jurisdiction against the properties, both registrations are required. Do it should be regulatory, isn't it, madam? No, it is statutory, Rajendra ji. The answer is statutory because the law provides for it. They are not regulatory powers only, they are even other powers. सिर्फ regulation से related powers नहीं आती है, they are guiding guidelines as well. Okay, so they are statutory. The answer here will be statutory. Now give me an answer for this question. See, if we are getting registered in one law, we do not require to get registered in another law. Okay? Is that the rule? See, when we are talking about SURFACI and other laws now, this sometimes SURFACI में तो अब सिर्फ साई के अगेंस्ट रजिस्ट्रेशन का टाइम पीरियड हटा दिया, बट अदर लॉज डू हैव दैट टाइम पीरियड. ठीक है. So this registration under SURFACI Act as well as other laws will have to be made as SURFACI Act is not substitution to other laws, because we are giving both a different standing. The SURFACI Act and the other laws have different standing, so we need to provide with double charges. So the answer here will be B. जनरल रूल है, हम एक काम को दो बारी नहीं करते. We do not do one thing twice. We do not make anybody go to jail twice. We do not make anybody to make payment for the taxes twice. But when we are talking about registration of charges, SURFACI Act में initially it was mandatory to make the charges registered, but अब ऐसा कोई provision नहीं है. But other laws do provide that. So if you're not going under SURFACI but you are going under the Companies Act, there is a requirement of charge registration. Okay. While filing appeal and before the appellate tribunal, if any amount is required to be deposited, no amount is required to be deposited until the appellate tribunal decides. Yes. Court fees on the appeal amount is required to be paid. Yes, 50% of the amount. 50% of the amount determined by the tribunal is required to be deposited at the time of filing the appeal. Yes, after admission of the appeal, 50% of the amount determined by the tribunal is required to be deposited. See, we know that there is a requirement. We have to give a 50% deposit. Is it before the admission or is it after the admission? The time is before the admission we have to deposit the amount. Okay, so the answer here will be C. Very good, Rajendra ji, very good. What is the time limit within which the adjudicating authority has to accept or reject the application? 20 days from the date of receipt of application, 7 days from the date of receipt of application, 14 days, 30 days. What is the timeline? Is it 27, 14, 30? No, it is 14 days. Who can initiate CAIRB? Only corporate debtors, financial creditors and operational creditors, financial creditor, operational creditor and corporate debtors and financial creditors. What is going to be the answer? The answer is C, not B. Financial, operational and corporate debtors सब CIRB के लिए जा सकते हैं. ठीक है. As per the Bankers Book Evidence Act, judge means judge of district court, first class magistrate, Supreme Court or High Court. Who will be a judge as per Bankers Book Evidence Act? It is a judge of High Court. D. D is going to be the answer. A court might order a bank to prepare and produce copies of entries relevant to a matter in issue accompanied by a certificate that no other entries are to be found in the books, and such order has to be served dash clear days exclusive of bank holidays before the same is obeyed. 3547. 3547. Yes, very good. It is A, 3 days. Next, Lok Adalats are organized under Lok Adalat Act. Are Lok Adalats organized in the Lok Adalat Act? Is there a Lok Adalat Act? Yes. The name of the act is Legal Service Authority Act 1987. The statement is false. ठीक है? पॉइंट इस लर्न कर लेंगे. ऐसे थोड़े से ट्रिकी क्वेश्चंस आएंगे. Next, presently the monetary ceiling of the amount of settlement through Lok Adalat is 10 lakh rupees. What is the ceiling? कितने अमाउंट तक लोक अदालत जुरिस्डिक्शन है, कितने अमाउंट तक की जुरिस्डिक्शन लोक अदालत के पास है. What is the upper ceiling? What is the monetary ceiling for Lok Adalats? Is it 10 lakh rupees? And if it is not, what is the amount, Rajendra ji, then? It is 20 lakh rupees, not 10 lakh. The answer is statement is false. Lok Adalats are organized for an area and usually consist of dash and other person specified by state authority or district authority or the Supreme Court Legal Service Committee or the High Court Legal Service Committee, or as the case may be the Taluka Legal Service Committee organizing the Lok Adalat. लोक अदालत में एक ऐसा पर्सन होना चाहिए, मतलब देयर हैज टू बी वन पर्सन स्पेसिफिकली, एक स्पेसिफिक जज के बारे में यहाँ बात कर रहे हैं. ठीक है, क्योंकि बाकी लोग तो जज नहीं होते. देयर हैज टू बी अ जज. क्या पोजीशन होगी उस जज की? कंसिस्ट ऑफ व्हाट? देयर हैज टू बी अ सर्विंग और अ रिटायर्ड जुडिशियल ऑफिसर. ठीक है, देयर हैज टू बी फॉर अ लोक अदालत, देयर हैज टू बी अ पर्सन हु इज आइदर सर्विंग एज अ जज और हैज सर्व्ड एज अ जज. ठीक है, so is serving or retired judicial officer. Next, which one of the following is the chairperson of the Central Consumer Protection Council? Very good question. Prime Minister, President, Finance Minister, Minister in charge of Department of Consumer Affairs. I have done approximately 55 questions till now. What is going to be the answer? It is Minister in charge of Department of Consumer Affairs. The President and members of National Commission holds office for such term as specified in the rules made by the central government but not exceeding 5 years from the date of which he enters upon his office and shall be eligible for reappointment up to the age of dash for the president and dash for other members. प्रेसिडेंट की एज कितनी होनी चाहिए मैक्सिमम? टिल व्हाट एज कैन अ प्रेसिडेंट सर्व इन अ नेशनल कमीशन एंड टिल व्हाट एज कैन अदर मेंबर्स सर्व? It is 70 years for president and 67 years for other members. लर्न करेंगे इसे हम. लर्न. नेक्स्ट क्वेश्चन. Any suit for which no period of limitation is provided elsewhere is this schedule in this schedule has to be filed within dash where the right to sue accrues. ये बहुत इंपॉर्टेंट क्वेश्चन है, ये बहुत इंपॉर्टेंट क्वेश्चन है जहां पे कोई लिमिटेशन पीरियड नहीं दे रखा, जहां पे कोई लिमिटेशन पीरियड नहीं दे रखा है वहां पे कितने समय के अंदर केस फाइल करा जा सकता है? 3, 12, 39। इट इज 3 years। जब कोई लिमिटेशन पीरियड नहीं दे रखा, इट इज 3 years। ठीक है। असाइनमेंट ईयर represents the period of 12 years beginning from 1st April each year following the relevant financial year। असाइनमेंट ईयर क्या होगा? इज दिस स्टेटमेंट ट्रू? 1st April से स्टार्ट होता है क्या असाइनमेंट ईयर? Yes, it is. It is true. Any person aggrieved by an order made by District Commission may prefer an appeal against such order to State Commission on the ground of facts or laws within a period of dash from the date of the order in such form and manner as may be prescribed. From District Commission, sorry, District Commission to State Commission, from State Commission to National Commission, from National Commission to Supreme Court. ठीक है, टाइम पीरियड बताएंगे इसका मुझे आप। यहाँ से देखो, डिस्ट्रिक्ट से स्टेट 45 days, स्टेट से नेशनल 30 days, नेशनल से सुप्रीम कोर्ट 30 days। तो आंसर इज बी, 45 days। ठीक है। Next, which of the following condition would render a complaint non-maintainable or ineligible under RBI Ombudsman scheme? The complaint concerns the outsourcing contract between dispute between bank and vendor. The complainant received a reply from the regulated entity from after filing a written complaint and filed a complaint to ombudsman after 1 year and 15 days. The matter in the complaint is already under adjudication by the consumer court. The complaint is submitted by the advocate on behalf of relative who is not a lawyer. The complaint is against a service outside regulatory purview, RBI's regulatory purview. What is going to be the answer? Answer here is, what will be the answer? Anji, waiting for your reply. C. Statement number 1, 3, 4 and 5 are correct. B is going to be the answer. Next, which of the following statement regarding passing of an award by banking ombudsman are correct? A ombudsman may pass an award if the complaint is not rejected under clause 16 and the matter remains unresolved despite a hearing opportunity. The award may include directions for specific performance or payment of compensation even if such compensation exceeds 20 lakh. Compensation for harassment and mental anguish is capped at 1 lakh and is separate from compensation for financial loss. Award will be considered null and void if the complainant does not enter a letter of acceptance within 30 days of receiving it. The Ombudsman is not bound to consider RBI's direction or banking law principle before passing the award. See, by reading it, there is one statement, even if you do not know the answer. ठीक है, doesn't matter. There is one statement by reading it, we know कि गलत है. क्या कोई भी जनन डायरेक्शंस ऑफ आरबीआई के अगेंस्ट जा सकता है? Specifically, the person who is appointed by the RBI. No, making fifth as incorrect. है ना? तो ऑप्शन नंबर ए एंड बी तो एलिमिनेट हो ही गया. And after reading all the above, we know that statement number 2 is also not correct. D is going to be the answer. Compensation cannot exceed 20 lakh rupees of the actual consequence loss, whichever is lower. Which of the following statement correctly describes the revised investment? मैं already बता चुकी हूँ. It is 2.5 for small and 10 crores turnover, 25 crore for small, for micro 2.5 cr, turnover 10 cr, small 25 cr, turnover 100 cr, medium enterprise 125 cr, and turnover 500 cr. And this applies uniformly to both manufacturing and service enterprise, making all of the statements as correct. A is the correct answer. Which of the following statement regarding the structure and power of National Board of MSME is correct? The National Board of MSME consists of 47 members, of which exactly half are ex officio. No proceedings of the board shall be invalidated solely due to vacancy or a procedural irregularity not affecting the merits. A person associated with the board for advice may vote during the board meeting. The board must convene at least twice every financial year. The board may advise the central government on the use of fund consolidated under section 12 of the act. What is the correct answer? It is C. 47 members may say 47 members तो होता है, but ex officio are 18, making statement number 1 as incorrect. Statement number 3 and 4 are also incorrect, making A as the answer. A is the correct answer. ABC Industrial Limited, a large manufacturing entity subject to statutory audit, procures raw material from various suppliers, including several registered micro small enterprise, for the financial year ending March 31, 2025. Which of the following situations are noted? As of the year end, ABC Limited has outstanding payment amounting 15 lakh in principal and 2.5 lakh in interest to MSE. During the year, 8 lakh was paid late after the appointed day, with 40,000 as interest under section 16. Additionally, 1.2 lakh of interest was payable for delayed payment beyond the appointed day, but this amount does not include the interest component specified under the Act. 75,000 of interest has accrued and remains unpaid at year end. ABC Limited fails to disclose the above in the notes of their financial statement despite being statutorily audited. Further, it ignores submitting information as required under Section 22. This is their second such violation. In reference of the above, identify which of the following are correct as per the statutory requirements and penalty applicable. ABC Limited is required to disclose all amounts in A to D in its annual accounts as per the disclosure norms applicable to audit entities. The amount of 1.2 lakh in C is exempted from disclosure because it excludes the interest specifically mentioned under the act. ABC Limited can be fined up to rupees 10,000 for its failure to submit the information under Section 22. Since this is second violation, it may be fined a minimum of 1,000 and a maximum of 10,000. Disclosure requirements apply only to MS, micro enterprises, and not small enterprises. Correct answer. A big question, a very big question. Such questions will appear in your exams. Read them twice. I've already read it once. Give a go. Make shifting the slide. Read the question again. Then we'll come back to the answers. We'll take a few minutes here. We'll reread the question. Please reread the question. Chale, let's see the answers now. Let's see the statements. What will be the correct answer? C. डिस्क्लोज करना कंपलसरी है. जब हम बोल रहे हैं A to D में डिस्क्लोजर जरूरी है, हाउ कैन वी एग्जेम्प्ट C, है ना? So either one or two, they are both contradictory to each other, and we know disclosure is important. Making two as incorrect. Making two as incorrect. ठीक है? Now disclosure requirements सबके लिए हैं. It is not just for MS micro enterprises or for small enterprises. It is for all. Making statement number 5 as incorrect. 2B is going to be the answer here. Okay. आपको what you need to do is you need to download this PDF from our app. The link is mentioned in the description box. Go ahead, download this PDF, read the questions, read the explanations. You will understand everything. Let's move forward. ABC Reconstruction was granted a certificate of registration by RBI in 2021 under SAFESI Act. However, in 2025, the RBI reviewed its operations and noted the following. The company has stopped all business activities related to securitization of asset reconstruction for over 1 year. It no longer has any investment from qualified institutional buyers. ABC has not submitted its books of accounts for inspection despite repeated reminders from RBI. The company failed to obtain RBI's prior approval before shifting its registered office from Delhi to Mumbai. The response to show cause notice, ABC requested more time to rectify some of its breaches. Based on the above scenario, evaluate the following statement. RBI may cancel ABC's registration without giving it any opportunity to be heard. Considering the gravity of multiple violations, failure to maintain investments from qualified institutional buyer is sufficient ground for RBI to cancel the registration. ABC has no right to appeal against RBI's cancellation order since the violations are substantial. Even if the registration is cancelled, ABC will continue to be deemed as ARC until all investors' dues are cleared. RBI must always provide an opportunity to be heard before cancellation, regardless the nature of violation. So RBI has the right to cancel anybody's registration, but the general rule says कि बिना आप किसी को सुने, without giving a person the opportunity of getting heard, you cannot cancel their license. And if you do so, you can go to court. Okay? But RBI can, if the violations are very serious in nature, RBI has immense power to cancel the license without hearing the other party. Okay? and nobody can take away your right to appeal. Making statement number 3 and 5 as incorrect. 1, 2, and 4 are correct. D is going to be the correct answer. Next. Which of the following statement correctly describes permissible actions under section 9 of the SURFACE for asset reconstruction? An ARC may take over management of borrower's business. The conversion of debt into shares of borrower's company is deemed valid retrospectively. ARC are now permitted to reschedule payment term of borrower's debt. ARCs can enforce security interest in line with SURFACE Act provisions. Reserve Bank of India has the power to regulate the management fees charged by ARC. A is the correct answer here. Let's move to another question. Which of the following power can a secured creditor exercise upon borrower's default under SURFACE Act? Take over management or possession of secured assets and transfer them through sale or lease. Appoint a manager to oversee the secured asset post possession. Demand payment from third parties who owe money to the borrower against secured asset. Directly approach Supreme Court to recover without DRT or civil court. Enjoy rights of ownership over a secured asset merely upon serving possession notice. See, there is a process you have to follow. ठीक है? आप सुप्रीम कोर्ट ऐसे नहीं जा सकते हो. You have to follow the path. पहले लोअर कोर्ट के पास हमेशा जाएंगे, then if you are aggrieved to the upper court, then to the higher, and then eventually to Supreme Court, and Supreme Court only if the question is regarding the law. Directly Supreme Court you cannot go. And if you serve a possession notice, आप possession ले रहे हैं, ownership नहीं ले रहे हैं. You are taking the possession merely, not the ownership. Ownership does not pass automatically. Making 4 5 as incorrect. B is the correct answer. Which of the following statement regarding the role of CMM DM are correct? Very important question. The CM or DM must take possession of secured assets and related documents within 30 days of receiving the written request, extendable by another 30 days with recorded reasons. The secured creditor may seek assistance from CMM DM only after receiving permissions from the tribunal under the SURFACE Act. The CMM DM or any officer authorized by them can use reasonable force to take possession of the secured asset. Any action taken by the CMM DM or their authorized officer for taking possession of the asset can be challenged under the Article 226 of the Constitution. Article 226 is the writ petition to High Court. Jurisdiction for approaching the CMM DM is based on the location of the secured asset or related document. What will be the correct answer? The answer is B. Statement number 1, 3, 5 are correct. Which of the following statements are correct with respect to takeover of management for a borrower's business by a secured creditor under SURFACE Act? Once a notice is published and new directors are appointed, all earlier directors or managers of the borrower company are deemed to have vacated their office and any existing management contract stands terminated. If the secured creditor have taken over management, shareholders or a borrower's company retain their rights to appoint directors subject to approval by NCLT. No winding up proceedings or receiver appointments in respect of such company can proceed in any court without the consent of secured creditor. On full realization of the debt, the secured creditor is obligated to restore management to the borrower even if it has required controlling interest through conversion of debt into equity. Directors removed from management after takeover is eligible to claim compensation for loss of office under Companies Act or their contract of service. What will be the correct answer? देखो, I'm not. If you are removed from being a director, ठीक है, secured creditor takes over the possession management of the business. The directors and the new directors are appointed. ठीक है, the old directors gets removed from their office and there is no such compensation that they can claim. Their contract will be deemed terminated the moment a public notice has been given, making one as correct and fifth as incorrect. Statement number 2 and 4 are also incorrect. Statement number 3 is correct. D is the correct answer here. All you need to do is read the explanations and watch the MCQ marathons that we have already had so that you can know in details कि क्या answer correct होगा and you will be able to give the answers. Which of the following statements are correct in relation to filing an application against measures taken by the secured creditors under SARFAESI Act? We have a session tomorrow in which we'll be covering BRBL. I'll try my best कि आपको पूरा concept and MCQs के साथ पूरा BRBL in 5-6 hours cover कर दिया जाए so that it gets you a revision of everything necessary. Tomorrow we have a lecture in which I'll fully complete BRBL for your exam. Will be exam prepared. ठीक है? An application, the timing for the session is 5 p.m. onwards. An application against the measure taken by the secured creditor can be filed only by the borrower and must be submitted within 60 days of creditor's action. The Debt Recovery Tribunal may restore possession or management of the secured asset to the borrower or aggrieved person if the creditor's actions are found invalid. The DRT can examine tenancy or leasehold claim to determine if such rights are valid for the purpose of enforcing the security interest. If the application is not disposed of by the DRT within 4 months, the party may approach the appellate tribunal to see directions for early disposal. The DRT can declare the actions of the secured creditor invalid even if such actions are found to be in accordance with SARFAESI. अगर आप SARFAESI के हिसाब से चाह रहे हो, ठीक है, if you are following the SARFAESI as it is written, the actions cannot be declared invalid. Making statement number 5 as incorrect, इससे हमारा option number B and D eliminate हो जाएगा. See, in some questions will appear in front of you in the exam जहां आपको पता है कि ये statement गलत है, जहां पे वो स्टेटमेंट गलत दिख रही है एंड जहां पे वो पॉइंटर्स आंसर में दे रखा है हम वहां पे उसे एलिमिनेट करेंगे. वी विल फॉलो द रूल ऑफ एलिमिनेशन. वी हैव टू, ये रूल ऑफ एलिमिनेशन सीखना बहुत इंपॉर्टेंट है आपके लिए. ठीक है, जो स्टेटमेंट हमें पता है गलत है हम उसको कट कर देंगे. वी नो स्टेटमेंट नंबर 5 इज इनकरेक्ट, तो हम वैसे ही ऑप्शन नंबर बी एंड डी को कट कर देंगे. अब हमारे पास सिर्फ 2 आंसर्स बचे हैं एंड विल सी क्या 2 आंसर्स में से स्टेटमेंट कौन सी स्टेटमेंट्स कॉमन है. 2 इज कॉमन इन बोथ, 4 इज कॉमन इन बोथ. ठीक है, तो यहाँ पे वी डू नॉट हैव टू अप्लाई आवर माइंड्स. ऑल वी नीड टू अप्लाई आवर माइंड टू इज स्टेटमेंट नंबर 1 एंड स्टेटमेंट नंबर 3. And after reading these statements, we will find कि क्या statement correct है कि नहीं, and it will make your answer easy. It will help you answer the question as fast as possible and you will save the time. आप लोग को बहुत ज़्यादा एक क्वेश्चन पे दिमाग नहीं लगाना पड़ेगा. And after reading, we know that statement number 1 is incorrect. Answer is C. The time period is 45 days, not 60 days. Next, which of the following statement correctly reflect the regulatory framework and implications of central registry and related SURFACE amendments? After 2016 amendment, every intangible asset like copyright trademarks must be mandatorily registered with the central registry. See, SURFACE में 2016 में we took this part that registration जो है मैंडेटरी तो है, बट क्या टाइम पीरियड है वो जो देयर वाज अ टाइमलाइन गिवन कि 30 डेज में रजिस्ट्रेशन, चाहे मॉडिफिकेशन हो, रजिस्ट्रेशन हो, सेटिस्फैक्शन हो, आपको करना पड़ेगा रजिस्टर. दैट पॉइंटर हैज बीन टेकन अवे, but the intangible assets point have been taken in consideration. The RBI may be delegated power to establish and regulate the central registry under 2016 amendment. Public notice is deemed to have been served from the date of filing any charge or order with the central registry. Prior of charge is determined, Priority of charge is determined by the amount of loan and not by the date of registration. Creditor holding a court order of attachment over a property can enter the same with surcease to establish priority. देखो, कोर्ट ऑर्डर को ना अगर आप रजिस्टर करा लेंगे, it will be beneficial for you because it will show that you have a priority over that order. ठीक है? And anyhow, whenever we make a registration over the charge now, we get the priority. And whenever we are getting the charge registered, the priority is based upon the date of registration, not the loan amount disbursement. We know from this that statement number 4 is incorrect and statement number 5 is correct. तो जहाँ पे statement number 4 है हम उसे eliminate कर देंगे. ठीक है? We have eliminated this, we have eliminated this. जहाँ पे स्टेटमेंट नंबर 5 दिया है वो करेक्ट है. वी नो दैट यहाँ पे सिर्फ यहाँ पे 5 दे रखा है, यहाँ पे 5 दे रखा, तो ये भी एलिमिनेट हो गया. मेकिंग व्हाट एज करेक्ट? मेकिंग सी एज द करेक्ट आंसर. डू यू नाउ गेट व्हाट इज द रूल ऑफ एलिमिनेशन? ठीक है. विच ऑफ द फॉलोइंग स्टेटमेंट Which of the following statement correctly relate to the provisions, definitions and interpretations under the Recovery of Debt and Bankruptcy Act are correct? The jurisdiction of DRT does not apply to claim below 10 lakh rupees. Is it 10 lakh rupees or is it 20 lakh rupees? And the threshold has remained unchanged since the enactment of the Act. The term debt under the Act includes liability arising from mistake committed by bank during the course of its business. The recovery officer is responsible for adjudicating debt between banks and borrowers. Multiple state cooperative banks are now considered banks within the definition provided under post amendment. The amount misappropriated by bank employee due to fraud does not qualify as debt under the Act. देखो, बैंक की गलती है, ठीक है. If bank has made some mistake, okay, then it will be termed as debt. And if the employee has made some misappropriation, it will not be termed as debt. इससे हमारी स्टेटमेंट नंबर 2 and 5 करेक्ट है. तो जहाँ पे 2 and 5 साथ में दे रखा है, विल करेक्ट दैट ऑप्शन, दैट इज डी इज गोइंग टू बी द करेक्ट आंसर, है ना. इसमें केसेस मेंशन है, आप प्लीज रीड कर लीजिएगा इस पीडीएफ में से. मिस्टर वाई, अगेन अ वेरी गुड क्वेश्चन. मिस्टर वाई वाज रिसेंटली appointed as a chairperson of a newly established Debt Recovery Appellate Tribunal of the central government. The official notification regarding his appointment was published in the Gazette of India. The government later issued another notification authorizing Mr. Y to also act as chairperson of another DRAT in a neighboring jurisdiction for administration convenience. Mr. Y, aged 67, has served as PO of a tribunal for 4 years prior to his appointment and had also been a member of legal services for 2 years. 1 year after his appointment, a PIL was filed. PIL is public interest litigation, challenging the legality of his continued appointment term and dual responsibility. Which of the following statements are correct in light of Recovery of Debt and Bankruptcy Act and the facts of the case? Mr. Y's appointment as chairperson of two appellate tribunals simultaneously is valid if properly notified in the official gazette. So, a government can do anything. He can appoint a single person as the head of two jurisdiction as well. तो chairperson उनको दो DRATs का बनाना is okay because the central government has done so and it has been notified in the official paper, official gazette. Next, Mr. Y does not meet the qualification of being a legal service, being in legal services for 3 years, so he is disqualified from appointment. But he was a PO of for 4 years. ठीक है? PO थे and legal services में थे 2 years. That is, he has an experience of 6 years, and the minimum requirement is 3 years. His prior 4 year services as PO qualifies him to be appointed as chairperson. Mr. Y can continue to the office till the age of 70 or completion of 5 years, whichever is early. A PIL challenging the dual charge may fail if it was duly authorized and notified by the central government. Give me an answer for this question. Give me an answer for this question. The statements are already explained by me. The answer here will be A. Statement number 1, 3, 4 and 5 are correct. Save statement number 2 incorrect hai. Which of the following statement regarding the filing of an application under 19(1) of DRT Act are correct? An application can be filed in the DRT where the defendant voluntarily resides or carry on business. The bank must withdraw its application under DRT before initiating any action under the SARFAESI Act. The DRT must decide an application for withdrawal within 60 days of date of filing. The application may be filed where the bank maintains the account in which the debt is outstanding. The DRT can deny withdrawal of application and must record reasons for it. See, the withdrawal is allowed. Okay? The DRT withdrawal is allowed and the DRT has to decide on such application within 30 days, making statement number 3 as incorrect. If we follow the rule of elimination, we have 3 given in A, B and C and we are going to eliminate all of these, making D as the correct answer. Please go ahead, give it a reading. Next. Which of the following correctly describes the role of 4 institutional pillars of IBC? The insolvency professionals are regulated individually who conduct resolutions and liquidation process. Information utilities act as judicial bodies to decide on insolvency petitions. NCLT and DRT are adjudicating authority under IBC for different types of entities. Insolvency and Bankruptcy Board of India regulates the professional agency and maintain oversight. Information utilities collate and authenticate financial information to reduce disputes. We know that under IBC, we go for insolvency and bankruptcy proceedings of companies and LLPs. And for insolvency proceedings or bankruptcy for, of individuals and partnership, we go to recovery of debt and bankruptcy code, RDB Act. ठीक है? So we have two authorities. That makes statement number 3 as correct. And statement number 3 ना देखो यहाँ पे सब जगह ही दे रखी है. ठीक है? Now apply your brains and see ऐसी एक statement जो गलत है. Are information utilities judicial bodies? Information utilities are financial data collector bodies, not judicial bodies, making statement number 2 as incorrect. When we are talking about all, it says 1, 2, 3, 4 and 5. तो 2 यहाँ पे भी दे रखा है, यहाँ पे भी दे रखा है and यहाँ पे भी दे रखा है, making all of them as incorrect. A is going to be the answer. Next. Which of the following statements regarding the adjudication and appeal process under the IBC are true? Appeal against order of NCLT can be made to NCLT within 60 days. अपील का टाइम क्या है? Is it 60 days? DRT is the adjudicating authority for individuals and partnership firm. Orders of NCLT can be appealed before the Supreme Court only on the question of law. Civil courts have jurisdiction in certain insolvency matters under IBC. Appeal from NCLT to NCLAT is allowed within 30 days, extendable by 15 days. देखो, statement number 1 में it is saying 60 days, statement number 5 में it is saying 30 plus 15 days. दोनों statement एक दूसरे को contradict कर रही है. So 1 and 5 can not be together in any of the answer. ठीक है? 1 and 5 यहाँ पे भी साथ में दे रखा है, 1 and 5 यहाँ पे भी साथ में दे रखा है. अब वी आर नॉट श्योर कि 30 डेज है या 45 डेज है, 30 डेज है या 60 डेज है. ठीक है? सो लेट्स पुट दैट ऑन होल्ड. यहाँ पे देखते हैं कॉमन में क्या है. इसमें कॉमन में 2 है, दैट मेक्स 2 एज करेक्ट. इसमें कॉमन में दोनों में 4 मेंशन नहीं है, दैट मेक्स 4 एज इनकरेक्ट. ठीक है? वी हैव टू चेक वेदर स्टेटमेंट नंबर 3 इज करेक्ट और नॉट. इफ वी डू नॉट नो कि 60 डेज है या 30 डेज है. ठीक है? कोई बात नहीं, हम एक ऐसे स्टेटमेंट देखेंगे जो दोनों में नहीं है एंड चेक करेंगे वेदर दैट स्टेटमेंट इज दोनों में है. मतलब देयर इज ऐसी स्टेटमेंट जो दोनों में से किसी एक में है एंड विल चेक वेदर दैट स्टेटमेंट इज करेक्ट और नॉट. ठीक है? इफ यू आर कंफ्यूज्ड कि 60 डेज है या 30 डेज है, विल सी स्टेटमेंट नंबर 3 हियर, क्योंकि यहाँ पे स्टेटमेंट नंबर 3 ही है जो अनकॉमन है दोनों में. ठीक है? जैसे ही स्टेटमेंट नंबर 3 का करेक्टनेस या इनकरेक्टनेस पता चलेगा, वैसे ही हमारे सामने आंसर आ जाएगा. So, the order from NCLAT can be appealed to Supreme Court only on question of law. Question of law. General rule is we do not go to Supreme Court directly. Plus, we only go to Supreme Court if there is a question of law, not fact. ठीक है? Making statement number 3 as correct. C is going to be the answer. Is this elimination rule now clear? Next question. Which of the following statement regarding the time limits and procedural aspects of CIRP under IBC are correct? The initial time limit for completion of CIRP is 180 days from the date of admission of the application. An extension of up to 90 days can be granted by the adjudicating authority, but not but only with the approval of 100% of community of creditors. Whenever we are talking about committee of creditor का approval for any process extension, it is 66%. This is the rule that you need to learn. ठीक है? And for withdrawal, देखो extension के लिए are going to court, going for insolvency. We need 66% of COC's approval. COC's committee of creditors. But for removal, but for withdrawal, of application, we need 90% approval. ठीक है? The CRP includes an extension, and time taken for legal proceedings must mandatorily be completed within 330 days. The rule is 180 days plus 90 days extension with 66% approval plus and maximum plus legal proceedings, which is equals to 330 days. 330 days के अंदर ये सब कंप्लीट हो जाना चाहिए. 330 days के अंदर ये मैक्सिमम टाइम पीरियड है. ठीक है? So now, the adjudicating authority may withdraw for an admission with 90% withdrawal के 90% mentioned है, and public announcement is made after the appointment of interim resolution professionals. ठीक है. Answer for this question. मैंने तो almost सारे ही pointers लिख दिए हैं यहाँ पे. You have to give me an answer for this. The answer will be C, right? 1, 3, 4, 5 are correct. Next, which of the following statement are correct regarding the appointment of resolution professionals by committee of creditors? The first meeting of the committee of creditor must be held within 10 days of its constitution. The COC must resolve by at least 66% shares to retain the interim resolution professionals or appoint new ones. If the board fails to confirm the proposed resolution professional within 10 days, the interim resolution professionals will continue until confirmation. The answer here will be, this is statement number 1, this is statement number 2, this is statement number 3. The answer here will be 2 and 3. B is going to be the answer because the first meeting is to be conducted within 7 days, not 10 days. ABC. Very good question. 100% exam type question. बिकॉज यहाँ पे हम वाटरफॉल मैकेनिज्म का कंसेप्ट 100% समझेंगे, ठीक है. In the ABC Limited has entered liquidation after its insolvency resolution process failed. The liquidator has realized 8 crores from the sale of assets. The following claims and dues are on record. Insolvency resolution and liquidation cost 1.2 crore. Workmen due for 30 months prior to liquidation commencement 2 crore. Secured creditors 3 crore, 3 total. Secured creditor 1 has enforced security and realized 0.5 crore against 1.2 crore owed. That is, इसको अभी 70 crore, so 70 lakh rupees देने हैं. We owe him 70 lakh rupees still. ठीक है. Secured creditor 2 and 3 has relinquished the security right interest. Combined claim is 2.5 crore. Employees workmen's unpaid salaries for 10 months 0.4 crore. Financial unsecured financial creditors 1.1 crore. Income tax dues 0.9 crore. Remaining trade payable operational creditors 0.4 crore. Preference shares and equity shares 0.5 and 1 crore. Based on the waterfall mechanism, which of the following statement are correct? Full payment of insolvency liquidation process must be made before any other claims. देखो, सबसे पहला 7 पॉइंट्स थे, हमने याद करे थे. सबसे पहला was to pay the cost for insolvency resolution process. तो स्टेटमेंट नंबर 1 तो करेक्ट है. जहां स्टेटमेंट नंबर 1 नहीं है, लेट्स एलिमिनेट दैट. Eliminated. Next is the dues to secured creditor 2 and 3 who have relinquished securities rank pari passu to workmen dues for the proceedings 24 months. That is second number पे हमारे आते हैं secured creditors, ठीक है. pari passu मतलब on equal rights. एंड थर्ड पे आते हैं हमारे वर्कमैन ड्यूज एंड एम्प्लॉयज ड्यूज. पहले वर्कमैन ड्यूज जाएंगे, फिर एम्प्लॉयज ड्यूज जाएंगे. वर्कमैन ड्यूज फॉर 24 months and employees dues for 12 months. Pari passu means on the same level. Since they have relinquished their securities, they are on the same footing as WD, that is workman deposits, workman dues. ठीक है. इन दोनों को साथ साथ पैसे मिलेंगे. क्यों? क्योंकि इन्होंने अपने रिलिंक्विश कर दिया सिक्योरिटी कि सबको पैसे मिल जाए, बेसिकली इस तरीके से. ठीक है. सो स्टेटमेंट नंबर 2 इज करेक्ट. 0 पॉइंट तो 2 जहां पे नहीं है, लेट्स एलिमिनेट दैट. ए हो गया एलिमिनेट. ठीक है. अब 1 एंड 2 दोनों में कॉमन है, तो हमें पता है, ठीक है. और यहाँ पे भी 5 भी कॉमन है, तो ये भी ठीक है. 4 के बारे में कहीं बात ही नहीं करी, तो हम 4 चाहे रीड नहीं भी करेंगे तभी चलेगा. प्रेफरेंशियल शेयर्स विल रिसीव देयर क्लेम्स बिफोर ऑपरेशनल क्रेडिटर्स. प्रेफरेंशियल शेयर्स को लास्ट में मिलता है, शेयर होल्डर्स को लास्ट में मिलता है. 7th नंबर पे है शेयर होल्डर्स. ठीक है. तो स्टेटमेंट नंबर 4 हमें पता है गलत है. इफ एनी अमाउंट रिमेन्स आफ्टर सेटिस्फाइंग ऑल अदर क्लेम्स इट गोज टू इक्विटी शेयर होल्डर्स और पार्टनर्स. बिल्कुल, हमने बोला कुछ बचेगा तो जाएगा शेयर होल्डर्स के पास. लेट्स सी स्टेटमेंट नंबर 3. 0.5 crore shortfall for SC1 who entered security interest rank below unsecured financial creditors. देखो, the ranking system was सबसे पहले IRP, then secured creditors, then workman dues and employees dues, then unsecured creditors, then government dues, then remaining debt, then shareholders. 1 2 3 4 5 6 7. ठीक है. जिस पर्सन ने सबसे पहले हम आरपी देंगे, हमें पता है, फिर सिक्योर क्रेडिटर्स को देंगे, एंड सिक्योर क्रेडिटर इन दोनों ने रिलिंक्विश कर दिए अपने राइट्स, तो हम लोग डब्ल्यूडी को देंगे साथ में 24 मंथ्स के लिए। अनसिक्योर्ड क्रेडिटर्स जो है हमारे फाइनेंशियल क्रेडिटर्स हो गए, ठीक है। अब अनसिक्योर्ड क्रेडिटर्स के बाद हम गवर्नमेंट यूज देंगे, सबसे पहले हम करेंगे गवर्नमेंट यूज की पेमेंट। अगर पैसे बचेंगे तो जो 0.7 CR बचे हैं ना इनके, मिस्टर SC1 के, उनको रिमेनिंग डेट्स में मिलेंगे, अंडर पॉइंट 7 मिलेगा, अंडर पॉइंट 7 मिलेगा। That makes statement number 3 as correct. Below, they rank below unsecured creditors. Yes, they do. Making statement number 3 as correct, B is going to be the correct answer. I hope you have understood this. I found that you need to understand this. That is why I have explained this too, although more explanations ज़्यादा needed नहीं है. Next. Which of the following are conditions specifically applicable to computer generated printouts as evidences? The computer system must be described in details, including safeguards against authorized data alteration. The system failure recovery mechanisms are not relevant for certification. The certificate must confirm that only authorized personnel could enter or modify data. The data stored on USB device or cloud servers is not covered under the Act. The separate certificate is needed affirming the accuracy and proper operations of system during the relevant period. What will be the correct answer here? Statement number 1 and 4, 2 and 4 are incorrect, making A as the correct answer. Next, which of the following statements are correct regarding legal outcomes and enforcement related to the Act? Certified copies are always final and need no further proof even if challenged. Courts can enforce court order against banks as if bank is a party to the proceeding. If a person disputes entries in a certified copy, no further evidence is required. The court can decide whether the cost incurred due to delay by the bank should be borne by the bank. Execution of the cost order can be initiated by civil courts as if they were a decree. The answer will be the answer here is A. 2, 4, 5 are correct. The real estate dispute arises between Mr. Sharma and construction company over delayed possession and refund. Both parties agreed to approach to Lok Adalat. After mutual discussion, a compromise is reached and Lok Adalat passes an award directing the company to pay a compensation to Mr. Sharma. Mr. Sharma, however, later changes his mind and files an appeal. If you have made a compromise in Lok Adalats, you cannot go to appeal. Meanwhile, the construction company fails to pay on time, prompting Mr. Sharma to seek enforcement of civil decree. Award को enforce कराना भी चाहते हैं, वो appeal में भी जाना चाहते हैं, दोनों काम करना चाहते हैं Mr. Sharma. During the process, the Lok Adalat summons a witness and examines him an oath. The court fees initially paid by Mr. Sharma at the time of filing the fees is also in question of regarding refunds. What is the following statement? Which of the following statement are correct in the context of the case above? The award passed by the Lok Adalat is deemed to be a decree by civil court and hence enforceable accordingly. The right, Mr. Sharma's right to file appeal against Lok Adalat award if he later disagrees with the compromise. The late Lok Adalat can summon witness and examine him on oath like civil courts. Court fees initially paid by Mr. Sharma is refundable after the compromise award is passed by Lok Adalat. All proceedings before Lok Adalat are treated as administrative proceedings and not judicial proceedings under law. Lok Adalat means people court. कोर्ट में एडमिनिस्ट्रेशन प्रोसीडिंग्स नहीं होती, जुडिशियल प्रोसीडिंग्स ही होती है. मेकिंग स्टेटमेंट नंबर 5 एज इनकरेक्ट. जहां पे 5 हम एलिमिनेट कर देंगे, ए तो हमारा एलिमिनेट हो ही गया. ठीक है, अब 3 सब में कॉमन है तो 3 है इज करेक्ट. ठीक है, नाउ गिव मी एन आंसर फॉर दिस. क्या स्टेटमेंट करेक्ट होगी और क्या नहीं? चले, what is going to be the correct answer? It is C. Statement number 1, 3 and 4 are correct. Let's move forward. Which of the following scenarios would disqualify a person from being appointed as an independent director under section 149(6)? A person was a firm partner in law firm that had 15% turnover from the company last year. A person's relative holds 60 lakhs worth of shares in holding company. You cannot be associated with any person जिसका आपका beneficial interest हो company के अंदर. That person cannot be an independent director. Independent director की definition is कि that person should be impartial and to be working for the benefit of the public and the company only. ठीक है, तो अगर आपके रिश्तेदारों का शेयर है, आपका खुद किसी तरीके से शेयर था, यू आर अ पार्टनर इन द लॉ फर्म, यू आर गेटिंग सच सॉर्ट ऑफ मनी, 15% ऑफ द टर्नओवर इज अ बिग अमाउंट. ठीक है, नाउ विल दैट पर्सन बी डिस्क्वालिफाइड? Will that person be disqualified? See, both the statements are correct, or though both of these persons will be disqualified. ठीक है, 10% gross turnover तक allowed है, इससे ज़्यादा नहीं. Which of the following are correct regarding the Income Tax Act? The company registered outside India would wholly controlled and managed by India will be treated as resident company. Income earned by resident individuals from a business in Singapore is not taxable in India if the money is brought into India during financial year was not brought. पैसे नहीं लाए तो क्या वो पैसे नहीं होंगे? इंडिया में नहीं आए पैसे, बाहर ही रह गए, तो क्या वो आपकी इनकम नहीं होगी? An individual who visits India for 150 days and has stayed 370 days in preceding 4 years will be treated as non-resident. 182 days is the rule. 182 days से कम कोई भी इंडिया में रहता है, he will not be considered as a resident of India. Income accrued outside India to a resident, not ordinary resident, from business set up and controlled in India is not taxable in India. The previous year is always financial year immediately preceding the assessment year, even for newly set up business. What will be the correct answer? For newly set up business, there is a different rule that I have already taught many times. And this is not the rule. Making statement number 5 as incorrect. जहाँ पे 5 है उसे eliminate करेंगे. ऑप्शन नंबर A and B eliminate हो जाएगा. B, C and D देखेंगे. C and D में 3 and 4 common है. 1 and 2 different है. We'll put our minds on statement number 1 and 2 only, which will tell you what is the correct answer. And the correct answer is D. Statement number 1, 3 and 4 are correct. Which of the following statement regarding GST and its treatment are correct? GST is a destination-based tax where revenue is collected by the state in which goods or services are consumed. Imports of services without consideration is never treated as supply under GST regime. GST subsumes both central and state government indirect taxes. Under GST, both central and state can simultaneously tax the same supply of goods and services within a state. Services imported by a taxable person from a related person without considerations are exempted under GST. So the rule is जो भी हम services ले रहे हैं whether it is for money or not, the answer is अब डी किसका आंसर दे रहे हैं राजेंद्र जी? ठीक है इसका दे रहे होंगे आप. ठीक है, give me an answer for this question. Yes, very good. C is the correct answer. C. हम furtherance of business देखते हैं, पैसे नहीं देखते. Whether we have paid the money or not is not important. We see why the goods are imported, why the goods are taken. If it is for furtherance of business, then that will be considered for tax GST purposes. ठीक है? C is the correct answer. Which of the following statement correctly describes the legal distinction between condition and warranty in a contract of sale? A breach of condition gives the aggrieved party the right to repudiate the entire contract. The breach of warranty allows the buyer to claim damages but not to reject the goods. The term initially classified as warranty can never be treated as condition even if it forms the essence of contract. जो वारंटी था क्या वो कॉन्ट्रैक्ट कभी नहीं बन सकता? Even though it is essential to contract. See, what is essential to contract is condition. Okay, if something forms as essential to contract, that will be treated as condition, चाहे वो initially warranty की तरह label हो रखा हो. Now, give me an answer for this question. C is the correct answer. Statement number 3 is incorrect. Which of the following statement correctly describes the position and right of unpaid seller under Sales of Goods Act? A seller is considered unpaid even if the price have been paid through a check that later gets dishonored. The term seller includes only the manufacturer who sold the good directly to the buyer. The right of lien can be exercised even when the seller is acting as a bailee for the buyer. What is the correct answer? What is the correct answer? Very good. A is the correct answer. Very, very good. Chale. Statement number 2 is incorrect. Which of the following statements are correct regarding different types of traditional partnership under Indian Partnership Act? A partnership at will can be dissolved unilaterally by any person through a written notice, even if no specific duration was originally fixed. A partnership for a fixed term automatically renews into a partnership at will if business continues post expiry without new agreement. A particular partnership, a firm continues indefinitely unless dissolved by mutual consent. What statement is correct? What statements are correct? What is the correct answer? Yes, very good. C is the correct answer. Statement number 3 is incorrect. We have remaining 5 questions with us. चलिए फटाफट करते हैं इसे. Which of the following statement accurately reflect features of LLP under LLP Act? Every LLP must have at least 2 DPs, one of whom must be a resident of India. LLPs offer limited liability protection to partners, but partners are still jointly liable for firm's debt. A person in an LLP is considered as agent of LLP but not to other partners. What is the correct answer? No. Not all the statements are correct. Rajendra ji, there is one statement incorrect. LLP में पार्टनर्स की लाइबिलिटी लिमिटेड होती है. Partners do not are not jointly liable for firm's debt. B is not, sorry, statement number 2 is not correct. Next, which of the following statement correctly reflect the principle of holding out by and right of transferee of partner's interest? A person who permits himself to be presented as partner can be held liable under the doctrine of holding out. Legal heirs of deceased partner are liable if the firm continues using deceased name. Important statement where people get confused. Where you will be confused. Okay? Transferee of partners in trust can demand access to firms during ongoing business. Thank you. Sorry. What will be the correct answer here? Sorry. Yes, very good. A is the correct answer. Statement number 1 के अलावा बाकी दोनों statements गलत है. Legal heirs are not liable merely because name is used posthumously. Sorry. Which of the following statement accurately reflect differences in management, membership, and liability between companies and partnership? A private company must have at least two and can have up to 200 members, whereas a partnership can have a maximum of 100 partners. A shareholder in a company needs the consent of all existing shareholders to transfer share, whereas in partnership, partners can transfer the interest in the firm freely. The liability of members in a company is generally limited, but partners in partnership have unlimited liability. If you have and know if you know the concepts. Yes, A is the correct answer. Very good. So I've received a question. Give me a second, please. Next question, next answer. Sorry. Next question. Which of the following statement? No, Kshitiji, you have to give JAIIB before appearing for CAIIB. पहले JAIIB देंगे and then CAIIB देंगे. Next, which of the following statement best describes the nature and structure of Article of Association under the Companies Act? Article of Association primarily defines the external scope of business and fundamental purpose of company. Provisions for entrenchment can only be introduced at the time of incorporation of a company. Entrenchment provisions require unanimous consent of all members in a private company for amendment. A very good question. A very, very exam worthy question. The answer is C. Only statement number 3 is correct. बाकी statements incorrect. ठीक है? Last question. Which of the following statement best describes the nature and structure of Article of Association under Companies Act? Article of Association primarily defines the external scope of the business and fundamental purpose of the company. अच्छी तो हो चुका है. Okay. So this question got repeated. So that was it. This is it from my side. We have done approximately 100 questions. If you have any doubt, कल lecture में आ जाएगा. I'll explain everything. We will completely understand BRBL. The whole BRBL will be taught tomorrow. We'll try to cover every aspect so that you clear your exam with very good score. Okay? Till then, thank you. Bye bye. We'll meet tomorrow at 5 p.m. And all the very best for your tomorrow's exam.